Okay, we're on the record in Ashley Day, case number. Sorry, case number 236628. The record should reflect Ms. Day is present here in the courtroom today. If I could have counsel put your appearances on.
Good morning, Judge. For the record, my call that. Good morning, you on the Day.
Thank you. This is the date and time set for a sentencing hearing in this matter. Ms. Day, have you had a chance to go through the pre-sentence report and talk to Mr. Kilo about that?
Yes, I have, Your Honor.
Okay. Mr. Kilo, are there any additions, deletions, or corrections to that report?
None, Your Honor. We believe this form is accurate.
Mr. Rolla, do people have any additions, deletions, or corrections?
Actually, Judge, just correcting what I believe to be a typo, because although the PSI is correctly scored on page 1 under current convictions and prior record, it shows 4 felonies, when in fact they attached to it and correctly scored, it shows in report 5 actually 2 felonies under item number 6 adult category, as well as 8, 9, and 10. So it would be 2 low severity and 3 high severity felonies. So it should be a 5, not a 4, Judge.
Okay, and I think that's correct, because looking at the there was a prior PSI attached to this one that indicated that it was her fourth. That one was her 4th, which would make this one her 5th. Mr. Kilo, do you agree with that change?
Yes.
Okay. So the court will order that the face sheet be in any other places in the updated PSI be changed to reflect.
I think that was the only spot there, Judge. Like I said, I think it was probably just a typo. I don't believe it, because PSI is properly scored, so we have no objections as to the scoring.
Okay, thank you. Anything on behalf of the people for allocution?
Briefly, Judge, the guidelines in this case are 10 to 28 up to 15 years as a recommendation of 2 to 15 years with 0 days credit. That's within the guideline sentence. I think under the circumstances as we're dealing with a possession of methamphetamine as an habitual second with the 6th felony, it's appropriate under the circumstances. Thank you, Judge.
Thank you, Mr. Kilo.
I just point out to the court, and the court already knows this, I know, that she was they're recommending 2 years and she's not eligible for the SAI program. I'd ask the court to adopt that recommendation.
Thank you. Ms. Day, was there anything that you wanted to say today?
Yes, Your Honor, I would just like to apologize to the courts for, I'm not from Gaylord, so I was being disrespectful to your town and the people here. But also I would just like to say that I have never asked for rehab. I've never been offered rehab. I understand that my scoring is very high. I have been in a lot of trouble, but all my cases are because of drugs, and I've never been offered or even asked for the help of rehab. So I would just like to take that in consideration.
I did read through the report that applies to this case, so I'm familiar with the facts that bring you before the court here today. And this offense, as I indicated, there was a PSI attached with your background information that also had information regarding a prior offense in Grand Traverse County. So I've got a pretty wide view of your circumstances. I agree. I mean, I think you certainly do have a substance use disorder, and I think that's something that you've been battling for a long time. From what I read in the report, you know, even when you were in prison the last time, you were finding ways to use in prison, which indicates to me that, you know, this is something that to a certain degree is out of your control. There's only certain resources that I have available, and once you develop a record up to a certain point that calls for prison recommendations, you know, the option of probation, which you've been on a number of times, is kind of out the window, and we're left with just kind of the punishment phase, and that's where we're at with your case now, unfortunately, because you're still a young person at 31 years old, still have a lot of life ahead of you, and even though the court isn't going to order rehabilitation, there's no reason once you're done serving your sentence that you can't seek that out yourself. And I think you're going to need to do that going forward, because otherwise I think you're just going to wind up repeating this pattern over and over again, because that's the way things have gone. You need to do something to break that pattern. As it is, the guidelines in this case, the recommendation is for a sentence that's within those guidelines. I think it's an appropriate recommendation. Given your conduct in this case, as well as your past history, I think it adequately addresses your wrongful conduct in this case. So the court is going to follow that recommendation and sentence you to the Michigan Department of Corrections for a period of 24 months to 15 years. Because you were on parole at the time of this offense, you are not entitled to any jail credit, and this sentence must be served consecutive to any penalty that you would serve for violating your parole. The court is also required to impose a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and the state cost of $68. You have the ability to seek an appeal of this sentence, and we're going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with any appeal. Or into the custody of the state at this time. People versus Troy Templeman, case number 1957088.
Morning, Your Honor. For the record, I don't have people.
Gary, do you know the
This is set for a status conference in this case. Templeman has been absconded for a period of time since, I believe, April 2022. He was recently apprehended, and so the court set this for a status conference. Mr. Gilo, have you had any opportunity to make progress on this file?
Yes, sir. We have an agreement with the court sanction.
Okay.
My client's going to plead guilty to count 1 and count 3. He's going to plead guilty as a habitual third. Count 2, and the rest of the counts would be dismissed. And that's it, as well as the head 4. So it's 1 and 3 as a had 3, and the rest of the counts dismissed, including the enhancement.
Mr. Zola.
Actually, it's counts 2, 4, as well as count 5, the half 4, and people also agreed not to pursue absconding charges. So it's actually a little bit better than what Mr. Gilo indicated, but that's the agreement here.
Right, can you say that again?
Yes, Judge. Defendant is pleading to counts 1 and 3 as a habitual third. Counts 2, 4, and 5 will be dismissed, as well as the habitual fourth enhancement. And the people also agree not to issue additional absconding charges.
Okay. All right. Mr. Gilo.
That's fine, Judge.
All right. Mr. Templeman, have you had a chance to speak with Mr. Gilo about this agreement?
Good morning. Yes, I have, sir.
Okay. And is that how you want to proceed today?
Yes, sir, it is.
Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Thank you. Good morning again. Mr. Templeman, are you currently on any kind of probation or parole?
No, sir.
All right. You understand that count 1, which is carrying a concealed weapon, as with the habitual third enhancement, that the maximum possible penalty that you could face would be up to 10 years and mandatory forfeiture of that weapon.
Yes, sir.
Okay. And count 3, which is possession of cocaine, as a habitual third, the maximum possible penalty you could face would be up to 8 years. Do you understand that?
Yes, sir.
With those maximum possible penalties in mind, what is your plea to each of those charges today?
I plead guilty, Your Honor.
Okay. Right now you have certain rights. I'm going to go through those with you.
Okay.
You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand that you have all those rights.
Yes, sir.
And can you tell me what's going to happen to those rights by you pleading guilty today?
I waive those rights.
That's correct. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to get this plea reversed, you'd have to ask the next higher court up, the Court of Appeals, to hear your case. They could say no, and then that would be the end of any appeal of the plea. Do you understand that?
Just to do right of a leave, is that right?
Correct.
Thank you.
Yes. Has anyone threatened you with anything to get you to plead today?
No, sir.
Has anyone promised you anything other than what we said here in court?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
And are you pleading guilty because you are guilty of each of these charges?
Yes, sir.
Okay. So this happened a long time ago, back in November of 2018. But at that time, were you here in Otsego County?
Yes, sir.
Okay. And at the time that you were here in Otsego County, I mean, was this whole thing part of a traffic stop or something?
Yes, Your Honor.
Okay. And that occurred here in Otsego County?
Yes, sir.
Okay. At that time, did you have a double-edged knife that was concealed on you personally or somewhere in your vehicle?
Yes, Your Honor, in the vehicle.
Okay. Did you have any kind of permit or other legal permission to carry that weapon in the way that you were carrying it? Okay. At that time, did you also have possession of some cocaine?
Yes, Your Honor.
And did you know that that's what that substance was?
Yes, Your Honor.
Okay. Did you have any legal right to have that at that time?
No, Your Honor.
Okay. Had you previously been convicted back in 1997 of unlawfully driving away a vehicle in Reporters Court in Detroit? I know that was a long time ago. If the records reflect that, do you have any reason to doubt that?
I don't have any reason to doubt it. What was the charge, sir?
It says unlawful driving away of a motor vehicle.
Car theft.
Yeah.
Yeah, it was an attempt. Yes, sir.
Okay. And then a carrying a concealed weapon offense in Mount Clemens in 2007.
Mount Clemens, Your Honor, in 2007, I was incarcerated.
Okay. Was that for an offense that occurred there in Mount Pleasant?
Your Honor, no, sir, I don't believe so. I was incarcerated in MDOC upstate for, oh, yes, it was, Your Honor. Yeah.
Oh, okay. I think we got it, Mr.
But you
Rolo.
know,
We're all set. Thank you. All right, with that testimony, Mr. Rolla, are the people satisfied with the factual basis?
Yes, sure, thank you.
Mr. Hilo?
Unsatisfied, thank you, Judge.
Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor, we believe the court's also by the courtroom statute as to acceptance, please, thank you.
Thank you, Mr. Hilo.
I agree with the court's by the statute and the actual basis. No other promises.
Thank you. Mr. Templeman, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea as to both. We'll set this matter for a sentencing hearing. Someone from the probation department will be in touch with you for a pre-sentence report. And then you'll be notified of the date, time of that hearing. It should be within the next 30 days. Mr. Hilo, anything further that we need to
No,
address? Mr. Roloff?
No, Your Honor, thank you.
Thank you, Mr. Templeman.
thank you. Thank you.
The next case we have is People versus Casey Bonomi, case number 216097. I believe this is a follow-up from last month. Mr. Leo, do you have any updates on Bonomi's case?
At this time, your honor, his whereabouts are unknown. Ms. Davis has not heard from him since I believe November.
Okay. And Mr. Gill, you're not representing him at this time, is that correct?
That's correct, Judge.
Okay. So, Mr. Leo, if you can just ask, Ms. Davis is the supervising agent, is that right?
Correct.
If you could just ask her to prepare a bench warrant for absconding, or to sign that, we'll proceed. And Mr. Bonomi's case, when he's arrested, brought before the court. I do want to note for the record that that hearing was set for 9:15 this morning. It's now 9:30, and Mr. Bonomi has not appeared in the court. Our next matter is set for 9:45. So Mr. Clayton, whenever you're ready with your client, just let the court officer know and we can get started. We'll take a recess until that. And the record should reflect that Ms. Jefferson is present here in the courtroom today. Ms. Jefferson, have you had a chance to go through the pre-sentence report and talk to Mr. Clayton about that?
Yes, Your Honor.
Mr. Clayton, are there any additions, deletions, or corrections?
I do have, the direct answer to the court is no, but I do have a request to the court. And I explained to Ms. Jefferson, the court is gonna do what it's gonna do. I had told Ms. Jefferson that I wanted her to check, get into inpatient counseling. I don't think that what she's been doing is working. She enrolled in outpatient counseling at Beverly Health. I don't think that's sufficient. However, this is a date and time set for sentences. I explained to her, this is a time the court set aside for her sentencing. She asked me if the court would adjourn her sentencing so she could get into inpatient counseling. And I told her that's a request I would make, but the court was completely at the court's discretion with input from Mr. Rollo.
Okay, Ms. Jefferson, that's not something that we're gonna adjourn the hearing for today. There's gonna be options for you to pursue that, but that's not a reason, I don't think, to stop today. I mean, we need to go forward with this, whether you're in treatment or not.
Right.
I think treatment definitely needs to be part of what you do going forward. But we need to get through this hearing today,
Yes,
move forward with the case.
okay.
And you can move that into your allocation.
I will, sir. My client asked me to make the request, and I explained to her that the court's position was likely to be what it actually was. So,
Okay. Thank you.
So the direct answer to the court, I don't have any additions, corrections, deletions. I also believe the guidelines are scored properly.
All right, thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to this morning?
No, Your Honor.
Anything by way of allocution on behalf of the people?
Yes, briefly, thank you. This is the first felony situation, but of course, the defendant has multiple prior controlled substance offenses. And the blood alcohol at the time was 0.236, some over 300 times the legal limit, or 300% times the legal limit. In any case, the guidelines are 0 to 9 up to 5 years. There's a recommendation of probation of 3 years with county time and 3 days credit. People believe actually, yes, that Ms. Jefferson probably benefit from some type of treatment. We don't think, however, that inpatient treatment for a drunk driving third should be used as a way of effectively getting out of jail. I think the court can impose a sentence that will allow for that. And if the court chooses to do so, I think the other recommendations are appropriate as long as they include $200 blood test reimbursement to the Otsego County Sheriff's Department. Thank you.
So I just have a question with regard to your allocution. I thought this was a controlled substance driving. I didn't see any blood alcohol. What I see is.
I'm sorry, 0.23 nanograms, correct, Judge.
Okay.
It's my apologies.
Okay.
Not BAC, nanograms of controlled substance.
Okay. Thank you.
Thank you.
Mr. Clean.
I was equally confused, and I don't know that it makes a difference, but at least we'd like to discuss what Mr. Rhodes' allocution is. Ms. Jefferson had methamphetamine in her system. 1 nanogram is sufficient under the statute. It's a Schedule 1 controlled substance. I think the point of my allocution is this, and I don't take umbrage with what the agent writes, other than how it's phrased. In paragraph 2 of the evaluation of plan, when asked why the appointment was scheduled, if she was not abusing or currently using alcohol or drugs, she said that her attorney advised her that it would look good to the court at the time of sentencing. That's not what her attorney advised her. What her attorney advised her was that if she didn't deal with her drug and alcohol issues, she was going to continue to be back in front of courts. Being back in front of courts was going to lead to longer and longer terms of incarceration, and that the fact that somebody is using methamphetamines is concerning to this attorney. That's what this attorney said. Not that it's going to look good in front of Judge Mertz if you're not using meth. Of course, it's going to look good in front of Judge Mertz if you're not using that. We don't do, at least I don't do my job to position what's going to look good in front of Judge Mertz. I position my job as what's going to make it so you're not back in front of Judge Mertz. So that's what I said. Okay, so maybe it's more of a semantics argument, but my hope for Heather isn't that she can look in front of Judge Mertz today on January 4th. My hopes for Heather is that she's never in front of you on any day going forward. And I think the only way that happens, in my opinion, in my years of experience, is if she seriously starts dealing with the underlying issues. I agree with Mr. Rolla, which I don't say often, but I agree with Mr. Rolla in the respect that Ms. Jefferson has a pattern that would lead a common sense person to say that she performs relatively well in society if she's not using alcohol or controlled substances. So that's why I was trying to inspire Ms. Jefferson to get into a program or something. And certainly I'm not a clinician. I don't know what is appropriate for somebody like Ms. Jefferson, but I think, you know, I've always been of the thought that if it starts out intense, and then goes into outpatient and then down to community supervision is usually the best, you know, the best course of strategy in doing these things. And that's what I was trying to inspire her to seek out, start intense, and then work down to a more managed care level. So there's nothing about Ms. Jefferson that I find personally to be not meritorious. I think she's a very fine person. I've actually, a lot of times, Judge, when I start out, and the court may not even appreciate this, but when I start out cases where somebody's a meth abuser, it's shocking, alarming, and somewhat satisfying to me when I watch their physical appearance change from when they're using methamphetamine to later on in the case when they're not. And we can sit in our offices and actually see that somebody's getting better because they're not putting that poison in their system any longer. And I've watched how their physical appearance actually get better, which is somewhat rewarding, you know, because at least whether it's the court order or my words or whatever it is, or a combination of the two, it helps people actually live better. Methamphetamine has gotten too pervasive in our system. It's killing people. And, you know, Miss Jefferson wants to be the best version of herself that she can be for herself and her kid. And I think that only happens with treatment and some sort of reinforcement from the court. So while I agree that maybe her last probation term wasn't stellar, she has successfully completed probation in the past. She's been supervised successfully. She does, to her credit today, come to court with her fines and costs, the ability to pay her fines and costs in full today. I think that's a testament to her taking this seriously. But I do recognize that there was a community risk issue that was involved here, and the court has to balance the 4 factors of sentencing. I simply am asking the court in this case to focus more on the rehabilitation aspects, because I do think she's amenable to rehabilitation, and focus a little bit less on the punishment. With the rehabilitation, I think goes hand in hand with the community safety. And, you know, it also would go hand in hand to a deterrent effect to others, that the court takes these kind of cases seriously. This is not something that is a small deal, it's a big deal. It affects potentially Your Honor driving on the road, it affects Brian Cleaver driving on the road, it affects Mike Rolla driving on the road. So, but I think the community safety aspect is more closely hinged to a rehabilitative sentence and less hinged to a punitive sentence.
All right, thank you. Ms. Jefferson, was there anything you wanted to say?
I'm supposed to start Bear River tomorrow. I have my 14-year-old son I take care of every day by myself. So I was wanting to be there for him still. I'm a single mom. This is what we take that into consideration. I do good on probation. I mean, I've completed a recovery court down in Jackson. I completed it successfully. You know, a really productive and meaningful member of society.
I did read through the report, so I'm familiar with the circumstances here that bring you before the court. There's also a lot of information in there about your past history, your background. So that gives the court a well-rounded view of you as a person generally, as well as the circumstances here. And taking all that into consideration, along with what both counsel and yourself had to say, number one, I think you're getting really good advice from your attorney, because I think he's right on in terms of where you're at and what you should be doing going forward, as well as just the outlook on his advice that he's giving you, which is not to just get through this probation, but to not be back here in the future. And that is really the goal of probation. And a lot of people look at it as, okay, I just got to behave for the next year or whatever, and then I can go back to doing what I was doing. But the point of probation is to get you on the right track, with the idea that you're going to stay on the right track. I also agree that the sentence in this case should address multiple issues. I think there should be some jail time with the potential for inpatient rehabilitation and credit off of additional jail time for that. I think probation is also warranted in this case, although your last term wasn't good. You have shown that you can be successful on probation in the past. So I think a sentence that incorporates some punishment with the prospect of rehabilitation and some supervision addresses all the concerns that we have, and does address what I think Mr. Clayton indicated is an important part of sentencing to me, which is public safety. And if you're not using, you've gone through an intensive rehabilitation program and you're not using, we're all better off under those circumstances than we are if you're just sitting for 9 months in jail.
Right.
So I think it's important, particularly in your case and where you're at, to incorporate that. So I say all of that to say that the court is going to sentence you to probation for a period of 24 months. The court is going to adopt as the conditions of your probation all the terms and conditions that are listed in the report. The court is going to order that you serve 6 months in the Otsego County Jail. The court's going to order that you serve 30 days of that up front. After 30 days, if you're eligible for a residential rehabilitation program, the court will allow you to be released from jail to attend inpatient rehab. And we'll give you day-for-day credit off the rest of the sentence for successful completion, and hold in abeyance any remaining jail time after. So if you're eligible for a 30-day program, you go in for 30 days. If you successfully complete it, you get that 30 days credit, and you don't have to serve the remaining time in jail. I think 30 days up front is important as a punishment to enforce upon you that there are consequences for endangering the public in the way that you did. But after you serve that upfront jail time, again, I think it's important, and it sounds like you're eligible, and Bear River will take you for you to get into a program. So the court, again, is going to sentence you to 6 months in the Otsego County Jail, 30 days up front. You may be released after the first 30 days to an inpatient treatment facility. The court will give you day-for-day credit for successful completion, and hold in abeyance any remaining jail time. Court will also, you do have 3 days of credit. Court will order a crime victims assessment of $130, a supervision fee while you're on probation of $30 per month. Court costs of $325, a fine of $500, a drug testing reimbursement fee of $200, a DNA testing fee of $60, and the state cost of $68. You do have the ability to seek an appeal of the sentence, and you can staff Miss Jefferson and County receive it for appellate rates.
Right there. This form that you're signing is going to your field rights form. If you wish to appeal it, that sentence would fill this out and return to the circuit court. Okay. For the record, I return to the court's clerk an acknowledgement of the advisor's appellate rights to the court.
The Jefferson Mertz.
Can I make a phone call that Samson can pick up his son?
You'll have to talk to
The jail will
them.
take care of that.
Good job, Woods.
Thank you.
There's somebody outside waiting for me. He's in a black Escalade. We want to know what's going on. He's right. He's right there.
I will. Okay.
His name's Dana.
Daniel?
His name's Dana.
Yeah. Okay.
Right. Mr. Chidsey, are you able to? Okay.
Yes.
Okay. And Ms. Wolf, are you able to hear me?
Yes, Judge, thank you.
All right, thank you. We're on the record in People versus Jonathan Chidsey. This is file number 2262596320 and 236492. The record should reflect Mr. Chidsey's present today by video from Michigan Department of Corrections. We have Mr. Roll on behalf of the people present here in the courtroom, and Ms. Wolf on behalf of Mr. Chidsey, also by Zoom video. Ms. Wolf, this is your motion to vacate the appointment and withdraw. I did have a chance to review the judge's copy of that motion. Was there anything that you wanted to state for the record today?
Well, Judge, I'll keep it really brief because I think the motion kind of speaks for itself. I do just want to add, since I filed the motion, I did send Mr. Chidsey a copy with the date of today's hearing and an additional instruction to contact me if he had any objection to the motion or wanted substitute counsel, and I still have not heard back. Of course, at this point, the appellate deadline for me was November 3rd of 2023, so I can no longer assist Mr. Chidsey, unfortunately, but I did just want to have this hearing and make sure that his rights are protected in case, you know, I've not done my job or he wants substitute counsel. Give him the opportunity to make that request, Judge. So thank you.
Thank you. Mr. Chidsey, did you have anything to say regarding the motion by Ms. Wolf?
No, I had sent her a signed copy back. Apparently she never received it. And with the holidays and then work and everything, I apparently never got back to her again, following up on that. So no, we're ready to vacate, I believe it was.
Okay, thank you. Mr. Rowland, do the people take any position?
Judge, as I indicated to defense counsel previously, we were not going to object to the motion.
Okay. All right, Ms. Wolf, I'm not looking at the files right now, but did you submit a proposed order or are you going to do that after the hearing today?
I didn't, Judge, but I'll send one right up.
Okay, so based on the information contained within the motion itself, Ms. Wolf's statements for the record today, as well as Mr. Chidsey's statements, the court will grant the relief requested. And Ms. Wolf, if you had to submit that order for signing, the court will sign that.
Perfect. Thank you, Judge.
Thank you. Mr. Chidsey, did you have any questions at all?
No, Your Honor.
Mr. Roll, anything further on this case?
No, Your Honor, thank you.
Ms. Wolf, anything further for the record today?
No, Judge, that was all. It's nice to see all of you.
Okay, thank you, you as well. All parties are free to disconnect at this time.
Great. Thank you.
And then Mr. Trish, I did give Ms. McHugh permission to attend remotely, but I don't see her connected yet, so. I'm assuming you had some contact with her recently.
I did. I provided her all the information and less than 5 minutes ago, she messaged me and said she'd be on Zoom.
Oh, well, and we're, in fairness, a couple minutes early there, so. While we're waiting, Mr. Church, would you mind just kind of moving that way a little bit? Earlier, I wasn't able to see Mr. Rollo. Are you ready on Ms. Bowen's case? We take that one.
There's a quick issue I want to discuss with her before we proceed, so I don't know if you want me to talk to her now or.
Actually, Ms. McHugh just popped up here. Ms. McHugh, are you able to hear me okay?
Yep.
Okay, we're on the record in People versus Heather McHugh. This is case number 236647. The record should reflect Ms. McHugh is appearing today by Zoom by prior approval of the court. If I could have counsel put your appearances on.
The record, Heather McHugh on behalf of the people.
Thank you, Your Honor. Richard Trush, appearing on behalf of Ms. McHugh.
Thank you. We're on the record today for a scheduling status conference. Mr. Trush, can you tell me where things are at?
Yes, Your Honor. We would be asking the court to docket this matter for a trial at this time.
And Mr. Rolla, will need any particular period of time to be ready for trial in this case?
I don't know about particular time to be ready, but there are 8 witnesses in this matter, so you're talking about at least a 2-day trial.
Okay. Mr. Trush, do you need a particular period for preparation?
No, as soon as the court can docket it, I think would be best.
And do you agree with a 2-day duration?
I have no objection to that. I believe that most of the defense witnesses are encompassed in Mr. Roll's listed witnesses.
Okay. All right, so the court will set this for a 2-day jury trial at its next available date. Pursuant to the usual practice of the court, we'll set this for a final status conference 30 days prior to the trial date. Mr. Rolla, are the people anticipating any pretrial motions? Are there any novel legal issues we're going to need to address in this case?
Well, Judge, there may be a situation where there's going to be a 404B motion with the expires. So I think that's the only matter that would be, but that would be a notice situation.
Other than any objection to make filed to those kind of notices, Mr. Truce, are you anticipating any motion practice?
I am not.
Okay, so we'll set it for a final status conference 30 days prior to the trial date. That will be the motion cutoff. Also, that will be a plea cutoff. So, Mr. Truce, just make sure that Ms. McHugh understands that when we have that final status conference, that'll be the last day that she would be able to enter a plea in this case.
Understood.
Mr. Roll, anything further for scheduling that we need to address on behalf of people?
Not for scheduling, but something I wanted to indicate for the record, if I may, Judge.
Sure.
Thank you. Defense counsel asked if people would consider allowing Ms. McHugh to plead to count one as a, with the drug double as opposed to the habitual second. We indicated that we would not object.
Okay, so the offer is count one.
Either as a have to or as a drug double, makes no difference to people.
Okay.
I think there's confusion. I believe that conversation was in regards to a different file.
I'm sorry then.
I think the offer in this, and you can correct me if I'm wrong, I believe the offer was a use as a double. Again, I believe that's.
I'm looking at the plea offer that was from 10/20/2023, and it indicates count one as a habitual second for dismissal of count two and other enhancements, including the habitual fourth and the drug double. So again, in either case, judge, makes no difference. That's what the offer was on October 23rd.
Okay.
Thank you.
All right, so we've got that for the record. So Mr. Truce, if you can just make sure you discuss that with your client prior to that final hearing date.
Absolutely.
Ms. McHugh, do you have any questions about how we're going to go forward in your case?
Yeah, I just didn't hear exactly what the plea deal was.
We'll talk about that, Heather. We'll have a discussion about it again.
Okay.
All right, so Ms. McHugh, the court will send out notice of the next hearing date. Make sure that you stay in touch with Mr. Truce so that you're prepared to go forward on that day, okay?
Okay, yep, thank you.
Okay, thank you. You're free to disconnect at this time. Mr. Truce, how much time do you need to speak with Ms. Bowen?
5 minutes.
Okay, we'll take a short recess. We'll come back on the record. It's 10:22. We'll come back at 10:30. Okay, we're on the record in People versus Amanda Bowen, case number 236644. The record should reflect Ms. Bowen present here in the courtroom today. If I could have counsel for your appearances on.
Thank you, for the record, I call behalf of the people.
Thank you, Honor Richard Trush, on behalf of Ms. Bowen.
Thank you. This is the date and time set for sentencing in this matter. Ms. Bowen, did you have a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, Your Honor.
Mr. Trush, are there any additions, deletions, or corrections?
There is, Your Honor.
Okay.
So to the body of the report on page CFJ 284, under the heading of family and the heading of marriage, Mark Bowen is listed under the family section as a stepbrother. Mark Bowen III is actually her stepson. And I think as such, I mean, those changes need to be made, that it's Mark Bowen III, it's stepson, not stepbrother. But I think it also rightly belongs under the marriage section, not the family section.
Okay. Do you also have a son, Ryan?
Yes, I do.
Okay, so
That's
that part's
also
correct.
But that's a stepson as well.
Yeah.
Okay, so we'll have, under marriage, we'll have Ryan Bowen reflected as stepson. We'll remove Mark Bowen under family and move that to marriage and reflect that that is Mark Bowen III, his biological son.
Stepson, Your Honor.
Stepson also, okay, stepson. Is the age correct on that?
Yes, it is.
Okay, any other changes, Mr. Church?
No,
Any challenges to the scoring?
no.
Thank you. Mr. Rowland, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections to the body of the report, nor challenges to the scoring. Thank you.
Thank you. Anything on behalf of the people for allocation today?
Judge, in this particular case, the defendant had on her person a stiletto that was found in her pocket. And the only reason I bring that up, and I understand we're not here on the sentencing of the stiletto because of course she played through counts 1 and 2. But I think it's still something the court should be taking into consideration for sentencing, because after being removed from her vehicle, lying about using or possessing methamphetamine, at least until after she tested positive for that, the defendant tried to hide the stiletto she had in her pocket. She did so even after exiting her vehicle, thus placing police officer Bowen specifically at risk. The court, under the circumstances, the people would respectfully suggest the sentence at least somewhere in the middle of the guidelines, not at the absolute bare bottom of the guidelines, if we don't think it's appropriate under the circumstances. Thank you, Your Honor.
Thank you, Mr. Church.
Thank you, Your Honor. I disagree factually with some of the assertions here. I mean, one, there's no question Ms. Bowen was under the influence at the time that this happened. I mean, it's clear from the officer's description of the engagement with Ms. Bowen. She was nodding in and out. She was not fully there at the time. But I think what is important about that is when the police officers asked her to step out of the vehicle, she did. When they asked her if she had anything in her pockets, she willingly took the items out of her pockets. And then when questioned about what items were, she identified what they were. So, you know, they asked her about what was in the bottle, or the clear vial, I think, and she told them it was methamphetamine. They asked her about what the pills were. She identified that they were methadone pills. So I don't think that this is a situation where she was, you know, being, I think, deceptive or dishonest to the police in that regard. I think she was upfront and honest with them. And again, I don't think she was in a right state of mind, but it does not appear to me from what I see that there was outright deception or even really an attempt to hide. I mean, she took the items out of her pocket. As far as the weapon, I never saw a picture of the weapon. I don't know exactly what it was. I think the court can probably identify from numerous cases it's had. Oftentimes people don't understand that they're carrying a double-bladed non-folding weapon or knife, that's a crime. I mean, they can be purchased at gas stations all over northern Michigan. The court's probably aware of that. People don't recognize that that's a felony offense. What we have here is Ms. Bowen is 41 years old. This is her first interaction with law enforcement in any significant way. These are her first charges, misdemeanor, felony, anything. It's her first real interactions with law enforcement. Again, she willingly cooperated in getting out of the vehicle, emptying her pockets, identifying items. The PSI recommends 30 days jail, suggested holding that in abeyance if she were to get an outpatient treatment. They recommended that to her on the date of the PSI because she did in fact test positive on that date, and she told them she used on that date when confronted with it. Well, she had used prior to that date. She immediately called to set up outpatient counseling, even though that was right before the holidays. She's followed up and she has an appointment to start her outpatient counseling. So I would suggest to the court that the court should allow her to complete that counseling, continue with that, and that the suggestion that the jail be held in abeyance with her doing that counseling is appropriate. I would further suggest that this is one of the rare situations, I think, where 2 charges could actually be taken under 7411. We identified that in hopes that the Department of Corrections would weigh in on that in the PSI, either recommending it or not. But I would ask the court to consider that because both of the offenses that she's charged with are eligible for treatment under that. And the statute specifically identifies that when someone's charged with this, the matter can be taken under that statute. So I think this is one of the rare circumstances the court could apply that to both charges. Ms. Bowen has a very good job. She works at Freddie's Market. She makes good money there. She has a home. She has a family. This is just behavior that we don't see in her past. And quite frankly, with the appropriate outpatient intervention, I have no reason to think we're going to see it in her future.
All right, I wasn't aware of this legal issue regarding 7411. Mr. Leo or Mr. Rowland, either of you take a position on that?
Judge, as indicated before to Mr. Cruz, people specifically when requested to include that, we would not. We don't think 7411 is appropriate. It's a situation, well, we also indicated that we would object to 7411 if that was requested at sentencing. We don't think under the circumstances that a person who's in possession of meth, in possession of analogs, and then contrary to what defense counsel has said repeatedly on the record this morning, did in fact attempt to hide the weapon. Yes, she pulled all the items out of her pocket and put them on the trunk, except for the stiletto that she chose to hide. Why she chose to do so, I don't know. And it is not a fixed blade weapon. It's a stiletto. That means it's a spring-loaded knife. The defendant clearly would know she's not supposed to carry such a weapon, but she chose to do so. She also chose to do so to try and hide it from the police. Those are what the facts are. This isn't some innocent person who, oh, I'm on drugs and I didn't know I had this scenario, because it's the only item she chose not to empty from her pockets.
Okay, and I understand your position with regard to whether or not 7411 generally should be granted by the court in this case. But as to whether or not it can apply to both charges, do you take a look?
If it's possession charges, Judge, I think the court can effectively do that should you choose to do so. I don't know that it applies to 2 charges though. I know it applies to 1. I suppose the argument's going to be, well, this arose out of the same matter. You can only get 7411 on 1 charge. So I don't see how the defense could argue that they did it for both charges, even though she's being sentenced at one time.
Mr. Trush, you think the statutory interpretation allows for that?
I do. And again, my reading of it is it refers to if someone is convicted of an offense, and then it refers to the matter being taken under the deferral statute.
Let me take a short recess. Again, I wasn't aware it was going to be an issue, and frankly, I've never had anybody bring that up before. So I want to take a few minutes to take a look at whether it can apply to 2 charges in 1 file or whether it's Okay, we're back on the record in People versus Bowen. I did look at that People versus Ware case. But I think that's a different issue. That's whether or not having two convictions would prevent one from qualifying for 7411 here. I question whether or not both can. I looked at the statute. In my reading of the statute, it applies to one conviction, not to multiple. I looked for some case law that applied specifically to this issue. I couldn't find any. And so I think, Mr. Truce, to the extent that you're asking the court to grant that, I think your obligation to bring forward some authority or a case that interprets a statute to mean what you're suggesting. My reading of the plain language of the statute, absent any case law to the contrary, is that it would only apply to one conviction. Not to both charges in this case, because these would be multiple pleas of guilt.
In light of that, I would ask the court to consider taking count one then under 7411.
Okay.
And if I feel like there's a basis to continue that argument, I'll file a post-judgment motion.
Okay, thank you. Anything else for allocution, Mr. Truce?
No.
Okay. Ms. Bowen, was there anything that you wanted to say today?
No, Your Honor.
Okay. I did read through the report. I'm familiar with the circumstances that bring you before the court today. I also reviewed your background and your personal history portions of that report, and taking all that into account along with what the lawyers had to say. You know, in my view, there's two really important factors here. Number one is your conduct. It's concerning to me that you were a vehicle in the state that you were in. To me, that's an issue that presents a concern for public safety. You don't want to be in that condition in any place, let alone in a vehicle. And so that concerns me for your prospects going forward, because that indicates to me that even if you haven't been in trouble in the past for this, that you do have a serious issue that you need to deal with. The other important factor, I think, is that you don't have any prior record. This is your first kind of encounter with the criminal justice system. And so I think that's a mitigating factor that warrants consideration here as well. I do think, considering 7411, number one, I think there's a practical problem of granting that status as to one charge and not the other, because one would be non-public, the other would be public. And from a practical standpoint, I don't know that the court can proceed on one file with part of it being a public portion and the other part of it being non-public. Aside from that, though, I do think the circumstances here, and in particular, the court's concern for your behavior in terms of public safety, don't warrant having this either charge placed under 7411 status. So the court is going to place you on regular probation. I do think that some jail time held in abeyance is appropriate in this case. You do have good employment. This is your first charge. And so I think under the current state of the law, the changes that the legislature's made for circumstances like yours, I think the court has to start with the presumption that some alternatives to jail time should be attempted before the court imposes jail. So the court is going to place you on probation for a period of 12 months. I think some supervision as we go forward is important, particularly to make sure that you follow up with the outpatient treatment, because I do think that's something that could benefit you going forward. And so the court is going to specifically make that part of the conditions of your probation. The court is going to impose 60 days in jail, but I'm going to hold that time in abeyance. So if you follow through with your treatment, if you comply with your probation, then you won't ever have to serve that time. But if you don't, then I think that's when the consequence and punishment phase needs to kick in as part of this case. So the court is going to, again, place you on probation for a period of 12 months. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. And that includes that you not use or possess any controlled substances or drug paraphernalia, or be with anyone that you know who has those kind of items. The court is going to order that you participate in and complete any treatment program that's recommended to you by your probation agent. The court is going to order 60 days in the Otsego County Jail. You do have credit for 2 days served. The court's going to hold that time in advance. A crime victim's assessment of $130, a supervision fee of $30 per month while you're on probation, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a state cost of $136. You do have the ability to seek an appeal of the sentence, and Mr. Church provide those papers to someone, please.
I'm returning the notice of appellate rights that's been initially dated.
Okay, thank you. And Mr. DeLeo, does Ms. Bowen need to meet with you before she leaves or check in with?
This day, so contact.
Okay, so Ms. Bowen, make sure you follow up with that contact once gets in touch with you regarding your probation.
Yeah.
Thank you. Good luck going forward.
Thank you.
Is Mr. Baird present?
Yes.
Okay, Mr. Baird, if you want to come up to the podium there, your attorney's connecting by video here, so. Right now. Okay, we're on the record, counsel and People versus Michael Baird. This is case number 236601. Mr. Baird is present here in the courtroom today. Can I have defense counsel put your appearance on the record?
Yes, good morning, Your Honor. Tyler Velo, P75702 on behalf of the defendant, Michael Baird.
Thank you, Mr. Rolla.
Thank you, Your Honor, for the record, McGraw, people.
Thank you. This is the date and time set for a status conference in this matter. Also to address a failure to appear back in December. Mr. Velo, can you tell me where things are at with this case from your standpoint?
Yes, Your Honor. My client would like to proceed to trial. We did have an unfortunate incident where my client was unable to appear. It was an incident where my firm's software was supposed to auto-notify Mr. Baird of the hearing. However, because he's going through a divorce case, it was disabled. And so I was under the impression that he got notice of this hearing. And so he did appear via Zoom, as did I. And he was in no way trying to not show up to court. But because of the software issue, he never got notice of that hearing. And so he is here today, as you can see. And we're asking that trial date be set in this matter.
All right, thank you, counsel. The court will accept counsel's explanation. Mr. Baird, the court's not going to impose any additional penalties for that issue, and the court will dismiss the show cause. In terms of trial dates, Mr. Rolla, do the people need any period of time to be prepared to go forward with trial?
No, Judge, it's 6 witnesses, so those people will be calling. I think maybe a day and a half. We might be able to get it in one day, depending on the circumstances. It is one where we're going to have lab people for the blood test.
Okay. All right, Mr. Velo, do you believe that 2 days would be enough time if the court sets aside 2 days for trial?
Yes, 2 days will be sufficient, Your Honor.
And Mr. Velo, do you need any particular period of time for the court to set aside before it sets this for trial to be prepared?
I'd ask for 45 to 60 days.
Okay. I'll set this out at least 90 days. That should give both sides adequate time.
Thank you, Your Honor.
Mr. Velo, are you anticipating any kind of pretrial motions or issues that evidentiary issues that we're going to need to address before we have trial?
Yes, Your Honor.
Okay, can you give me just a quick synopsis of what issues? I just like to have a heads up about what may be coming down the pipe here.
This is a low BAC case. It would likely be challenging the validity of the tests, but the senior partner at the firm and the owner, Barton Morris, would be doing the final review and deciding the motions in this case.
Okay, thank you. Mr. Rolla, are people anticipating any kind of pretrial motions?
No, Your Honor, thank you.
Okay. All right, so Mr. Velo, the court is going to set this for a final status conference. It'll be about 30 days prior to the trial date when we get that. That'll be the motion cutoff, so any motions will need to be filed and heard no later than that date. If your motions are going to involve, more time that are going to need more time than, the 15 minutes that we would normally set aside on a motion day like this, then I'll just ask you to inform my assistant at the time that you set it for hearing, let her know how much time you think you're going to need so that we can set aside the appropriate amount.
Understood. Thank you, Your Honor.
Okay. And then Mr. Velo and Mr. Baird, that final status conference will also be the plea cutoff. And so that means that would be the last time, to the extent that there are any further plea negotiations or discussions, that would be the last date to enter a plea. And after that final status conference, then we would be going forward to trial. So Mr. Velo, just make sure that you have those discussions with Mr. Baird prior to that hearing so that he's ready to make a final decision.
Definitely, Your Honor.
Okay.
Judge, could we get a correct address for Mr. Baird? We had some returned mail from him.
Mr. Baird, can you give us a current address for you?
1115 Eagle Drive, Wayland, Michigan, Wayland. 49348. And it's apartment 107, or I'm sorry, 105.
Okay, so if we send mail, you'll get it at that address.
And I did call the court when I moved. I did call and left a message.
That's the address we have, but we still got returned mail. So.
Okay.
All right, well, that's one we're going to send it to. Okay. So whatever you have to do, and you can always, again, check with your lawyers. They'll make sure that you are aware of the dates.
For sure.
Okay.
Thank you.
All right, Mr. Rolla, any further dates that we need to address for scheduling today?
I don't believe so, Judge. Thank you.
Mr. Velo, any other dates that you wanted to address regarding sentencing?
Nothing further, Your Honor.
Okay, so the court will send out notices of hearing for that final status conference date, as well as the trial dates. I'll also send out a copy of the scheduling order so that counsel has that. And that's all I have for today. Mr. Baird, did you have any questions about how we're going to go forward?
No.
Okay, thank you. That's all for today.
Okay, thanks.
Thank you, Your Honor.
Mr. Velo, you're free to disconnect at this time.
Thank you, Your Honor. Have a great day.
Thank you. Mr. Slocum, are you ready with Mr. Orman's case? I am. Okay. People versus Jared Orman, case number 236658. I can have counsel put your appearances down.
For the record, Your Honor, I call that people.
Jeff Slocum on behalf of the defendant, Mr. Erman, who was also present with me.
Thank you.
May I approach you?
Sure.
Explain where we're going to.
Great, thank you. Okay. It looks like we have a plea. Can you tell me the terms of that, Mr. Slocum?
Your Honor, it's my understanding that if my client offers a plea to an added count 2 of attempt of count 1, that the count 1 charge would be dismissed.
Mr. Rolla, is that a correct statement of the plea offer?
That's correct, Judge. It'd be attempted, and the statute is 800.2813 in bracket A, that reduces it to a 2.5-year, $500 public safety violation.
Okay, thank you. Mr. Orman, have you had a chance to talk to Mr. Slocum about this plea agreement?
Yes, Your Honor.
Okay. And what we've all said here this morning, is that consistent with the agreement that you've discussed with him?
Yes, Your Honor.
Is that how you want to go forward today?
Yes.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Lower your hand. Mr. Orman, are you currently on any kind of probation or parole?
Yes, Your Honor.
Okay, is it probation?
Probation.
Okay, where is that out of?
Otsego County.
And Mr. Slocum, is this plea going to affect that probation? Are you aware?
It will not, Your Honor. As when the court will hear from the facts of the case, it was the start of the jail time for that probation is when this incident occurred.
Okay. All right, and Mr. Orman, you understand that the maximum penalty that you can face for this charge, which is attempted bringing contraband into a correctional facility, that's up to 2.5 years and or a $500 fine.
Yes, Your Honor.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty, Your Honor.
And Mr. Slocum's already gone through your rights with you here through this form, but I'm going to go through them with you here on the record as well. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to appeal it or get it reversed, you'd have to ask the next higher court up, the Court of Appeals, to hear your case. If they said no, then that would be the end of any appeal of the plea today. Do you understand that?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today?
No.
Is it your own free choice to enter this plea?
Yes.
And are you pleading guilty because you are guilty?
Yes.
This happened on August 29th of 2023. Is that the correct date?
Yes.
And on that date,
One more thing.
Sure.
I was giving it some thought. It was on, it just started his probationary sentences. And I was informed by the probation department that they, if this court was going to take action on this charge, that they weren't not going to, but it could result theoretically in a penalty with the district court. So I guess that tiny correction should probably be made, I suppose.
okay. And that probation is through the district court, not through Department of Corrections.
Correct.
Okay.
And
So the representation, Mr. Slocum, was that they were not going to pursue a violation if there were charges brought.
That's my understanding.
Mr. Roll.
That's my understanding as well. We're dealing with an offense date of August 29, 2023, so we would have been on probation at that time in the district court.
Okay. So, Mr. Orman, I do want to clarify that with you, because you were on probation at the time of this offense. It could potentially result in a violation of that probation. But it sounds like there's been representations made that won't be violated, so it's unlikely that you would receive any additional penalties. But you understand that that's a possibility?
Yes.
Does that change anything about your willingness to enter this plea today?
No.
So back just discussing what happened in this case, it was back on August 29th, 2023.
May I inquire, Your Honor?
Sure.
Okay. On August 29th of this year, you were, that was supposed to be the first day of a 30-day jail sentence you were receiving from the Otsego County District Court for a drunk driving charge. Is that correct?
Right.
And when you turned yourself in at the Otsego County Jail, you were obviously in Otsego County when you turned yourself in, correct?
Yes.
And at the time you turned yourself in, you had on you an Adderall. It's a Schedule II drug, correct?
Yes.
It was prescribed to you, but you knew that the jail would not allow you to take that prescription or give you the prescription in the jail. Is that correct?
Yes.
So you actually secreted on you in your anus to to get it into the jail with the intent to get it in the jail without the jail being aware of it, correct?
Correct.
And you understand that the jail is a correctional facility and they have everything that goes along with that, correct?
Yeah.
Okay. Thank you. I think that would be a sufficient factual basis for the plea, Your Honor.
Mr. Rolla?
People would agree, yes, Your Honor, thank you.
All right, Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on record?
No, Judge, we feel the court's complied with statute and court regarding acceptance of pleas.
As do I, Your Honor.
Thank you. As to both issues, Mr. Slocum?
Yes, Your Honor.
Thank you. Mr. Orman, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. You're going to meet with Mr. DeLeo from the probation department before you leave here today to set up a pre-sentence interview. Other than that, just make sure that you stay in touch with Mr. Slocum prior to that sentencing date. Mr. Roll, anything else we need to address on this file?
No, Your Honor, thank you.
Mr. Slocum?
Thank you.
No, thank you.
Thank you, Your Honor.
Our next hearing is set for 11:30 with Mr. Erman. Sets until that time.
Unless you don't want to go on the record, your choice. In either case, it's kind of a bit of a moot point because let's see, where's the case here? Hang on a second. I think if the court looks at People versus Johnson, 336 Michigan Appeals 688. It was a 2021 case, but then the court of the cert was denied. So I think I don't even think this is even an issue anymore in regards to DNA costs. But so maybe I told Richard about the case, so maybe he saw it in the.
When did that case come out that you're referencing?
2021, Judge. People versus Johnson. Johnsson, common spelling.
Well, I don't know. I mean, the way that I read the Court of Appeals order is if he's already submitted a sample, then I have to take off the $60 fee. And if he hasn't, then I can leave it out.
I think that's correct, right.
Okay. Do you know whether or not he had previously been assessed that?
If you give me a minute, I can try and tell you. I'll have to look. But then again, they don't always include that in judgment, so that's a little
Right.
difficult. So give me a second.
Okay.
All right, Mr. Erman. I pulled his bond sheet originally to indicate whether or not DNA is he had it before.
Okay.
That's what we're looking for now.
Okay, we're on the record in People versus Thomas Erman, case number 236463. Mr. Erdman is not present today, and neither is defense counsel. We do have Mr. Rolla. For the record, the issue set for this hearing, this case was returned to this court by the Court of Appeals to determine whether or not Mr. Erdman had previously submitted a DNA sample and been charged for that, that would comply with statute. If he had, then the court was to remove the $60 fee that it imposed at sentencing in this case. And if he had not, then the court was to take no action. Mr. Rolla has some information on that.
Yes, Sean, thank you. It appears actually that he had previously been ordered to do so back before this court, 46th Circuit Court at Otsego County, case number 13-4707 FH. Would have been count 11. Number of the other counts were dismissed. And that would have been for an offense of delivery, manufacture, MDMA, or ecstasy as a habitual offender second. And looks like it was ordered in that case, as well as he also had a second offense before the 46th Circuit Court in case 13-4681. And that was, it looks like on June 5th, 2013, for actually operating and maintaining a methamphetamine lab where the court also ordered DNA. Okay. I can't tell what you charge for it then because I don't have a copy of the judgment, but I can provide the court with that information.
Okay, so based on that information, the court finds that Mr. Erdman should not have been assessed a $60 fee in this file. the court will direct the clerk to prepare an updated or amended judgment of sentence, removing the $60 fee. The court finds that it's appropriate to proceed on this today without the defendant present because the ruling is in his favor and is the most favorable ruling we could get. So that's all for the record on this file. That concludes the court's morning docket, and the court will be in recess until